I'm Bella. We used to say Alice, but now it's McCallum as of a month ago today. So I remember to say that. My husband Chip is sitting on the front row being as supportive as usual. And I wanted to start by thanking Balch again so much for the use of this assembly room time and time again and supporting us with these events. We really appreciate it. So, our speaker tonight, Justice Greg Shaw, and I go back a long way to Montgomery, Alabama, where his wife, Samantha Shaw, was one of the first mentees before mentee was a word of my mama in Montgomery, Waxy, Lancaster, and that's really kind of how I first met them. However, he did graduate from two of my favorite schools, Auburn University and Cumberland, and he got a Master of Laws from the University of Virginia School of Law after that. Now, a lot of y'all older people in the room might have followed his appellate career after he left private practice, where he worked for both Justice Shores and Justice Houston, and he's going to be talking a little bit in his speech tonight about his work with Justice Shores. But after that, he went to the Court of Criminal Appeals, and he is now a justice on the Alabama Supreme Court, about to run this year for his third term there. You may know that his wife, Sam, was the former state auditor of Alabama, having served in that capacity before she retired for 2 terms. And she is not with us tonight. I'm going to explain to you a little bit more about where she is as we proceed through the intro. They passed their extreme smartness onto their sons. They have one who's a graduate of West Point and the other one who graduated from Georgia Tech, both in mechanical engineering. They had the real smarts not to go into law, and both are married. But what you probably don't know about the Shaws and about Greg is that he is one level before becoming a master beekeeper with 12 hives at his house. And his biggest concern right now, other than this election, is whether he's going to beat the percentage of loss of bees through the winter season, which he and Sam are trying hard to do. She is actually down at Auburn today teaching something that has to do with beekeeping that he told me about. And please don't forget his nurturing side, as when a mama pygmy goat rejected her baby on Christmas Day. Justice Shaw has been bottle feeding the baby ever since that time. He certainly knows his topic tonight, separation of powers, a firm foundation of judicial decision making. And we really do appreciate in this busy time for him traveling all the way in this rainy weather to speak with us tonight. If y'all could welcome Justice Shaw.
Thank you, Nicole. Appreciate it. Can I just let these sit here? And I guess that'll pick up. Maybe this.
If your voice is as loud as mine, you can.
I don't want to hit this too much. The little goat's name is Annie, or Little Orphan Annie. We periodically, I have a pygmy goat herd, and periodically a mama goat will reject her baby for various reasons, and a lot of times it's because the mama will have twins, and she will abort the first one, and then somehow, in the confusion of that, she will wind up walking away from the second that comes after the first one. And when that happens, it's very difficult to get them to take back the baby. And so this is about the 4th one that I have had to raise on my own, and they all think I'm their mom. We bring them into the house. They stay in the house for about two weeks, 2.5 weeks. In a dog crate, and this little goat right now has about reached her limit because what I want to if you know anything about goats, when they reach about 2 years old, their legs turn into springs, and they have the ability to jump incredible heights, and they love to do it on your furniture. And, I have had them jump right in the middle of some of our furniture and just knock pictures everywhere. And so she's about to be introduced to the herd. Anyway, that's more information about goats than you probably wanted to hear. Thank you, Lavella, so much for that introduction. I have, when I was thinking about what to speak about tonight, I wanted to sort of reminisce a little bit and talk to you a little bit about some of my experiences. I'm a great admirer of the Inns of Court. I think this organization shares the same principles and objectives that dovetail real closely with my overall judicial philosophy and my approach to decision making and my actual views on the legal profession as they've developed over the past 40 years or so. And I know the mission of these organizations, is to foster a legal profession and a judiciary is dedicated to mentoring, relationship building, professionalism, civility, ethics, and excellence. And there's a little bit of all of that in my story that I want to tell you about it. I have been told that y'all absolutely will get up and walk out at 7 o'clock. So I'm going to try to move along. I've tried to, during my career, I've tried to live up to these ideals that the Inns stand for. And I hope some of my remarks tonight will benefit you to a certain degree. It's a true honor to be asked to speak to such an esteemed group of lawyers and law students. Jack and I go way back. He'll always be Professor Hood to me. He taught me civil procedure in the fall of 1979. That goes back a long way. So I'm a little bit intimidated. But I thought this may be my only opportunity to make Jack stand up and participate in that so-called Socratic method. Not really. But it's really good. He was pretty easy on me, and he was one of my favorite professors because I actually made a B. I don't know if you recall or not, but I don't know how many A's you gave, but I made a B, and I was mortified when I finished your exam. We had those little books, and when I wrote for 3 solid hours as fast as I could write. And when I got through, I finished about 5 minutes before the end of the time period, and I went back to check. I couldn't read a word of it. My handwriting got so bad in law school trying to take notes. I said, Professor Hood will never be able to read this. And then it occurred to me that might be a good thing. So, obviously, there was enough there that I got through. Thank you, Jack. It's good to get back with you. So I thought I might take a trip down memory lane tonight and reminisce a little bit about some of my earlier days as a lawyer and sort of how I came to develop my approach to decision making. And I don't know how you feel about decision making philosophies. I think that there are some folks that have a more liberal philosophy than I do. Some that may have a more conservative philosophy than I do. But, that's what the purpose of the Inns is to share experiences and to share ideas and different approaches to the legal profession. And I think that's a good thing. The path of my legal career, the evolution of my approach to judicial decision making has steered me away from what I call an elitist, I know better than you approach to legal scholarship. And I've always thought of myself as a conservative jurist, and I sort of wear the mantle of a blue-collar conservative jurist. I have a textualist, originalist approach to appellate dispute resolution. That's who I am fundamentally. And I think that you know, in the law schools today and among the general public and among lawyers, you know, across the board, I think there are different viewpoints as to how you approach statutory construction, how you approach constitutional interpretation. And I love to hear the different views of judges, and especially appellate judges and lawyers on that. But I thought I'd share my views with you tonight. You know, I'm not a professional public speaker. I'm never truly comfortable doing it, but I enjoy challenges like this. I appreciate being asked because really it takes me out of my comfort zone. And I love, though, talking to lawyers who practice well our profession, because I consider our profession to be the most difficult profession to navigate conflict. And so I love talking to lawyers. I love hearing lawyers' ideas. And I've learned along the way that preparing comments like these sort of force me to dig deep and figure out what I truly believe and share those ideas and get feedback. So that's what I thought I'd do tonight. You know, time is a bit limited. So I just thought I would give you an evolutionary progression of how I've sort of evolved over the past 35 years in my journey from a Supreme Court senior staff attorney to a Supreme Court justice, and how that progression was shaped by a particular doctrine that we all are familiar with, and that is the doctrine of separation of powers. So it began on September the 4th, 1984, and I walked into the Cumberland School of Law to begin the first day of work with Justice Jane Shores. Justice Shores' staff attorney had left in the middle of his term with her and had gone to the 11th Circuit Court of Appeals. And she needed someone to come on board, and I wanted to be that someone, and she was gracious enough to hire me. And I walked in that day, and she and Red Jones and Oscar Adams all had offices there in Birmingham, at Homewood. And their law clerks were there. And I had never seen the inner workings of an appellate court. I mean, I had never been that close to Supreme Court justices. I had never worked on a case, you know, for the Supreme Court. I was basically clueless when I walked in that day. And it was a stressful situation. It'd be an understatement to say that I was under a certain amount of stress. But Justice Jones's senior staff attorney, Ann Wilson, who was still a very good friend of mine, she befriended me, got me a desk, really just a table, got me a chair, and told me I could sit right there. And then she showed me the shelf, and it was divided up, Justice Shores, Justice Adams, Justice Jones, with all of the cases bundled up that needed to be worked on. Mandamus, cert petitions, direct appeals, and suggested that I might want to start with a cert petition just to get my feet wet, and that was a very good suggestion. And so I started by opening up that petition, and the only instruction that I had been given by Justice Shores was, "Don't embarrass me." Now, I don't know how many of y'all knew Judge Horton. We were personally, I worked for her for an entire year. Justice Shores was a taskmaster. Justice Shores expected you, once you became a lawyer, you needed to act like a lawyer, you needed to be a lawyer, you needed to do what a lawyer does without having a lot of prompting. And she basically expected me to be a self-starter. She expected me to go in there and figure out how to do this job if I wanted to keep it. And so that's literally what she told me. Don't embarrass me. And it was very stressful when I started, but looking back on it after 40 years, it was really one of the best things that ever happened to me in my career was working with Justice Shores, because she forced me to realize that you could achieve excellence, and you could achieve it very quickly if you want to get a paycheck. And so I owe a great debt to Justice Shores. But at the time, I was scared to death of course. And so was her law clerk. I was her senior staff attorney, and she had one law clerk. And we did everything we could to make sure that we went by the letter. So how was I supposed to extrapolate a judicial approach to decision making, which I was expected to do from the words "don't embarrass"? Well, the short answer is I did what a lot of new law clerks and staff attorneys have done over the years, and I followed the outline that's in Southern Reporter. In other words, I read a lot of opinions. I also treated each case as if it was my own, as if it had my name going on it. I always put the law first. I never compromised when to do so would affect the work product. I accepted the result with no predisposed thoughts as to who would prevail. And this is probably the most important thing. I was always ready and able to defend every position that I had taken without equivocation. And I assumed that if I did these things, then surely I would not embarrass myself, and by extension, I wouldn't embarrass Justice Shores. And it turned out that the approach that I just sort of an ad hoc approach has served me well during my tenure with Justice Shores. Rarely did she question one of my recommendations, and when she did, I was able to respond to it and defend what I had given to her. And I don't recall really changing a whole lot. And as I began to develop through that year, I gained more and more confidence. I was still scared to death of her, but we began to sort of understand each other, and it was very, very rewarding to have gone through that year with Justice Shores. And like I say, I think the fact that she sort of threw me into the deep end of the pool and said swim forced me to sort of think, well, how am I going to swim? And in this particular situation, it forced me to go back and look at some of those things that I learned in law school, like the doctrine of separation of powers. And that's sort of the blueprint that I used when I worked on every case for her. Then later in my career, of course, I moved on to work for Justice Gorman Houston. And I just began to think of this ad hoc approach of mine as just my way of vindicating the rule of law. And it served me well with my 15 years with him and through my transition from staff attorney from the Court of Criminal Appeals to from staff attorney to the Court of Criminal Appeals and then to the Alabama Supreme Court. Justice Houston's philosophy and my philosophy and his approach and my approach were very similar. Both of us approached statutory construction, constitutional interpretation, and things of that nature in a very similar manner. He was an excellent writer, still is an excellent writer, and I developed my writing style to complement his because I was writing for him. And we actually got to a point where we could divide opinions up. He would write the first half, I would write the second half, we would get a transition paragraph, and you would never know who wrote that. Someone other than Justice Houston had actually personally written the first part of the opinion. And that's basically how I learned how to write legal opinions, was through working with Justice Houston, Justice Shores, and with George Earl Smith, who was our reporter of decisions for so many years. He was a professional grammarian, and he would correct every one of the draft. He corrected every one of the draft opinions that was to be released. We still have that person today, Billy Cawley, who does that now for us. Every opinion before it's released goes through a grammatical review process by two grammarians, and they correct with their red pens what we write. And as long as they don't touch the substantive part of it, we pretty much go along with what they do because they make us look better. One thing that we used to do, Justice Houston and I, we like to diagram cases on these dry erase boards. And it was kind of a bittersweet thing because he took my office and turned it into a conference room for us to do that. And so, although I enjoyed it, I did not have the office that all the other state attorneys have with the window. But I look back on those years with great fondness. You know, the decision-making process at the appellate level is not a complicated process in theory. However, the devil is always in the details. The practical application of any analytical approach can get dicey. For instance, to vindicate, I talked about my role was to vindicate the law. To vindicate generally means to justify or support. And law generally refers to a body of enforceable rules that govern conduct. So my approach to judicial decision-making evolved over the years into a process whereby I strove to justify or support the body of enforceable rules that govern conduct in any given case with any given set of facts, and then to accept the result of that process. But the law, you know, has to be identified, and that's always not an easy task. Not enough time to talk about that, but suffice it to say that sometimes figuring out what the law is that's applicable in a particular case is the primary issue in the case. And the second part of that, the law must be justified or supported. Again, this is not always a given. And this is where, you know, my views and your views may diverge, I don't know. I personally view this responsibility as an ethical issue for a judge or a justice when you talk about justifying or supporting the law. You know, in my view, every judge or justice should put aside his or her personal feelings concerning, you know, desired policies and results and focus solely on the law. And I think a strong understanding of the doctrine of separation of powers has provided many judges, including myself, a roadmap over the years for staying the course. This particular doctrine promotes stability and consistency in the law by prohibiting the judicial branch from competing with the legislative and executive branches if it is adhered to. Often it's not. And I've also relied heavily on procedural rules that govern judicial decision-making, and I believe that they should be adhered to even when no one is looking. And this comes about when we have to make hard decisions. Usually it's on cert petitions, it's on concerns mandamus petitions. We have certain rules of initial review that we have to do. And it's frustrating, to say the least, to see the number of lawyers in Alabama who don't understand the appellate rules well enough to file a cert petition or to file a mandamus petition, or sometimes even to file a direct appeal. It's very frustrating. And I've always tried to follow our rules and treat every one the same. To a certain extent, I think the evolution of my approach to decision-making has jaded me a little bit, in the sense that I have never been one who cares a whole lot about consensus building. I've never cared a whole lot about compromise when it comes to deciding cases of appeal. A lot of people find that surprising. I usually come to a conclusion on a case based on the law, based on the facts. And once I have made up my mind after doing all of my research, I usually will not come off of that position until someone pushes me off of that position and showing me that I'm wrong. I've never been one who was really willing to compromise just to get votes. And if you go back and check my record in the Court of Criminal Appeals, you'll see that there were a lot of concurrences in the result. Matter of fact, Champ Lyons asked me one time, why couldn't I concur more? And I said, well, you know, if they would write it the way I wanted it every time, then I could. You know, I think it's one of those situations where it's not, you shouldn't confuse confidence in putting the law first with arrogance. It's not arrogance, it's putting the law first, focusing on the law. And I've just never been one to compromise away material principles of law me that's not going along to get along. Now, I'm just telling you all that just to sort of tell you kind of how this whole thing evolved. But I want to get back to the main point of my talk, and that is the doctrine of separation of powers. When I walked into Cumberland to begin my first day on the job, I was a young green staff attorney, and I needed to quickly figure out what it was that I was expected of me and what I was supposed to do. And like I said, I must have been listening, Jack, that day that we talked about separation of power. I think it was Professor Hutchins was my professor. Didn't care.
Con law.
Con law. And I was paying attention, thank goodness. When he talked about that, stare decisis. Stare decisis is another topic for another day, but I was paying attention. You know, I understood when I started working for Justice Shores that you could not develop a proper approach to judicial decision making without fully understanding and respecting that doctrine. Now this goes back to the point that I made about this being an ethical issue for a judge. The doctrine itself pervades the judicial making process if you think about it. If you understand the role of the judicial branch of government, whether it's state or federal, then you necessarily understand the proper role of the judicial decision maker. At least as that role was understood by the founders of this republic. Now, if you just tuck that away as I go forward, if you do not understand the role of the judicial branch of government, whether state or federal, then you do not understand the proper role of the judicial decision maker. You know, the founders of our country, our republic, were, to me, brilliant visionaries. You know, they envisioned a republican form of government that could simultaneously govern adequately and resist what history has shown to be a natural tendency in organized governments to adopt tyrannical policies and restrict freedoms. And power was sought to be diffused, not centralized. And that diffusion of power was contemplated at both the state and federal levels. The more layers of protection the founders believed, the better. 3 branches of government were contemplated: executive, legislative, and judicial. The legislative branch was believed to be the more dangerous of the 3 in terms of its perceived tendency to dominate the other 2. And both the legislative and executive branches were scrutinized for their perceived tendencies to dominate the judicial branch, which was perceived as the weakest and most vulnerable of the 3 branches. And great concern was expressed over the independence of the judicial branch. The perceived role of the judicial branch was to exercise neither force nor will, only judgment. Neither force nor will, only judgment. The whole concept of separating powers within a government was to avoid any one branch of the government from venturing over into the domain of another. In other words, the contemplated role of the judicial branch in the governance of this nation, in my view, was extremely limited. In the Federalist number 78, Alexander Hamilton, in his customary defense, enthusiastic defense of the Constitution, he stated this. As I was doing some preparation for this talk and a talk I gave to the Federalist Society, I came across this language and it just really caught my attention. I'm quoting here from Alexander Hamilton. Whoever attentively considers the different departments of power must perceive that in a government in which they are separated from each other, the judiciary, from the nature of functions, will always be the least dangerous to the political rights of the Constitution, because it will be the least in a capacity to annoy or injure them. The executive not only dispenses the honors, but holds the sword of the community. The legislature not only commands the purse, but prescribes the rules by which the duties and rights of every citizen are to be regulated. The judiciary, on the contrary, has no influence over either the sword or the purse. No direction either of the strength or of the wealth of the society, and can take no active resolution whatever. It may truly be said to have neither force nor will, but merely judgment, and must ultimately depend upon the aid of the executive arm even for the efficacy of its judgments. So Hamilton, that's the end of that part of the quote. Hamilton equivocated a little bit with the following appeal to those who would in the future comprise the judicial branch and be judicial decision makers like myself and others at the state and federal level. And I'm quoting again from Hamilton. It equally proves that though individual oppression may now and then proceed from the courts, the general liberty of the people can never be endangered from that quarter. This is it. I mean, so long as the judiciary remains truly distinct from both the legislature and the executive. So in Hamilton's argument for the structure of our government under the Constitution was that everything would be okay with a judicial branch as long as the judicial branch remained truly distinct from the legislative and the executive. So that was a hopeful thought by Hamilton during this discussion, the public discussion that was being had about the Constitution. And I think that so long as proviso was far more important than Hamilton probably ever realized it was going to be. You know, to me, it appears that Hamilton failed to fully appreciate the allure of the power that can be wielded by the judicial branch through its ability to interpret the nation's source document, which is the United States Constitution. That very power opened the door for the judicial branch, if unrestrained, don't lose sight of that, if unrestrained, to both legislate for and administer the government. Those were two things that Hamilton had satisfied himself simply would not happen down the line. Now, when I talk about if unrestrained, what is a court? A court is people. It's people. It's judges. So if you talk about is a court going to restrain itself, you're talking about are people going to restrain themselves. Now you're talking about what is your judicial philosophy. How do you view constitutional interpretation? Now you're getting into the nitty-gritty of what was really bothering Hamilton. Now, Hamilton's enthusiasm was lost on a man named Robert Yates, who was a New York delegate to the Constitutional Convention. He was an anti-federalist opponent of the Constitution. Writing under the name Brutus in the New York Journal, he noted in his 11th essay, and I'm quoting again, "The real effect of this system of government will therefore be brought home to the feelings of the people through the medium of the judicial power. It is moreover of great importance to examine with care the nature and extent of the judicial power, because those who are to be vested with it are to be placed in a situation altogether unprecedented in a free country. They are to be rendered totally independent, both of the people and the legislature, both with respect to their offices and salaries. No errors they may commit can be corrected by any power above them, if any such power there be, nor can they be removed from office for making ever so many erroneous adjudications. The only cause for which they can be displaced is conviction of treason, bribery, and high crimes and misdemeanors. This part of the plan is so modeled as to authorize the courts not only to carry into execution the powers expressly given, but where these are wanting or ambiguously expressed, to supply what is wanting by their own decisions." Still quoting. "They will give the sense of every article of the Constitution that may from time to time come before them. And in their decisions they will not confine themselves to any fixed or established rules, but will determine, according to what appears to them, the reason and spirit of the Constitution. The opinions of the Supreme Court, whatever they may be, will have the force of law, because there is no power provided in the Constitution that can correct their errors or control their adjudications. From this court there is no appeal." And in his 15th essay, Yates noted this, quoting again, Perhaps nothing could have been better conceived to facilitate the abolition of the state governments than the Constitution of the judicial. They will be able to extend the limits of the general government gradually and by insensible degrees, and to accommodate themselves to the temper of the people. Their decisions on the meaning of the Constitution will commonly take place in cases which arise between individuals with which the public will not be generally acquainted. One adjudication will form a precedent to the next, and this to a following. And that's the end of that quote. So you can see the tension that existed between those who were debating the establishment of our branches, our separate branches of government, and especially debating how dangerous the judicial branch could become down the line. You know, this Yates made no bones about his concerns. Hamilton, though, was enthusiastically arguing in favor of the Constitution. It was arguing in favor of this structure. And I think Hamilton looked at it as a glass half full. Yates was looking at it probably as a glass completely empty. But I think in the back of Hamilton's mind, he was wondering, you know, this will only really and truly work. The Republic will only be best served if judges and justices understand that they're supposed to stay in their lane. They're supposed to stay, you know, they're supposed to stay in the lane that was created for the judicial branch, and not venture over into the lanes created for the legislative branch or the executive branch. Which is another way to say that this system really only works in the way that the founders intended for it to work if a judge very, very, very carefully weighs how far that individual will go in imposing personal views on policy into the law. And we see that struggle every day. We see the ramifications of it. We see the battles that take place in Washington, confirmation of Supreme Court nominees. Different people have different ideas about how judges should approach these issues. And I think that will be ongoing. But I think one thing that is for sure, that probably all of us in this room could agree on right now, is that the judicial branch has turned out to be no wallflower. The judicial branch has not turned out to be the least dangerous branch of government in the United States. Whether it's the most dangerous, I guess, would be a matter of discussion at another time. But again, it goes back, in my view, to how individual judges view and how much they respect the doctrine of separation of powers, which the founders believed was a bedrock principle in the formation of this country. So, you know, if it was generally understood by the founders, and I think it was, that the very essence of the separation of powers doctrine was to restrict the functions of the judicial branch, and thus the functions of the judicial decision maker, to exercise judgment only and not will. Keep in mind that that's supposed to be the function. And I have to ask myself, by what authority do I, or does any other judge, state or federal, who is subject to that doctrine, or what authority do I otherwise analyze cases differently? I mean, it's clear to me now, at least, that my understanding of and my respect for the doctrine of separation of powers, which I believe, as I said a while ago, is a bedrock principle from which our government is based, is what led me at the onset of my career at Cumberland, the Supreme Court, when I entered Cumberland that day on September the 4th, 1984, to develop the very approach that I still use today. And that is vindicating the law, as I describe it, by identifying the law through me personally, through a textualist, originalist approach, always putting the law first, accepting the result with no predisposed thoughts as to who will prevail. That's extremely important to me. No predisposed thoughts as to who will prevail. I don't go into a case with an end in sight. If you follow that pattern, if you follow that philosophy, you just think about it, it'll naturally lead you to exercise judgment, not will. So if I am not looking at what result I want, if I'm not looking at what policy I think Congress should have adopted, if I'm not looking at those things, if I'm looking at how am I going to resolve this dispute that's here before me right now, and I don't care who wins, that the law has to be justified here. If I do that, the only thing that's going to happen there is I'm going to exercise judgment. It's not going to be my will. But again, that is a personal approach that every individual who wears a black robe has. Some judges will go ahead and step over that line. Some judges won't. And so that's why I have often thought of this as an ethical issue, at least in my mind. So just to sum up, I think that my decision-making approach and that of like-minded judges would probably satisfy both Hamilton and Yates, if you think about it. It was what Hamilton hoped for. It's what Yates said needed to happen. However, I also believe that the existence and the probable predominance of what Justice Scalia once described as other, quote, seductive and judge-empowered philosophies, close quote, in federal state courts and law schools, and even the perception of many of our citizens, would probably vindicate Yates, but would really, really concern Hamilton. These are just some of my thoughts on these issues, and I hope that I've made good judicious use of your time.